evidence, there was no investigation that was achieved by coercive, or information that was achieved by coercive methods. All you're left with, and that is debatable on the papers about the timing and who was responsible for the timing. But let's assume for the moment that Mr. McCarthy wanted to have a particular timing. How does that make the prosecution a bad one?
So, if I may respond this way, Justice Nafsa. So we know what the conduct was. We know what McCarthy was doing. He was trying to delay it, and we must accept that he was trying to delay it because there was concern that if the indictment was served before Polokwane, it may boomerang in the sense that people may rally around Zuma and President Mbeki would not get re-elected. So that is the conduct. Now, the court said
Mr. Epstein, Mr. Epstein,
in the judgment.
Before you proceed, can you fact check this in your response? When did Mr. Mshe finalize the authorization of the poker and of the institution of poker proceedings? Didn't he finalize it around December?
Well, the decision to prosecute was taken, I think, 29 November, but I'm a little off guard. I don't know the date of the poker.
But when did he sign?
Was it the 12th of December, 11th or 12th of December?
Yes.
Yes, I think that my memory serves. I think you jogged my
perhaps
memory.
Perhaps you can look at the chronology.
Yes. So the court said, in our view, this is in the judgment at paragraph 52 of the quota quo. In our view, the alleged conduct of Mr. McCarthy, as appears from the transcripts of the recorded conversations, if proven, constitutes a serious breach of the law and prosecutorial policy. It is not even necessary to refer to his role in the Browse-Moore report, for which it seems he was not admonished. His conduct as alleged in the transcript, again if proven, certainly calls for intervention. This will involve an inquiry into the allegations, and if need be, also censure by court of law. So the courts found that this conduct was a serious manipulation. It constituted a serious breach of the law, and the DA believed also it was conduct. They say
manipulation of what, Mr. Epstein? What is the manipulation?
So, Justin, if I could just get there, if I could just have a moment. So, the court criticizes the conduct. They say, if proven, we submitted. It was the NDPP's discretion to take into account what he had. He didn't have to go to court to prove it, notwithstanding the court said that it should have been taken to court. So what do we have? What is the essence? What did he do? McCarthy was in a position to have the indictment served. Downer wants to proceed. Downer wants to proceed
but
because...
when was it finalized? When was the indictment itself finalized?
Justice Chiki, the decision was taken 29 November to prosecute. I think poker was round about 12 December, and the indictment was served, I think, just after Polokwane, 27, 28. Poker was signed 14 December 07, just before Polokwane.
Just before Polokwane.
Yes.
But its actual finalized, when was it ready for it to be served on Mr. Zuma? Because my sense of the papers is that if we put aside the debate on when it should have been served, whether it should have been served before Polokwane or after Polokwane, the point, well, my sense of the papers is that it was in any event ready only after Polokwane.
I think, Justice Chiki, the certificate, the indictment can be served without a certificate. The poker certificate only has to be available at trial, provided the party hasn't pleaded. So whether they were waiting for the poker certificate, I'm not sure, but they certainly, Mr. Downer was very upset when he was told that it would be postponed, and he made a lot of noise about that. He made it clear that he didn't want it postponed, and this was the egregious conduct.
What has been put to you by my colleague is the following, that objectively on the facts, because there was a few things had to be done before Polokwane that whether or not there was manipulation was overtaken by events, because the indictment was only ready for service on or about the 14th of December. Nobody was going to, over a long weekend, start serving indictments. So whether or not there was manipulation, in fact, the indictment could only be served after Polokwane, which means that to the extent that there was manipulation, it is in any event irrelevant because it had no bearing on the ultimate timing. That's as I understand
Justice
the question.
Justice Kachai, I think with respect, we see from the transcripts that Bulelani Mulka was saying to McCarthy, whatever you do, don't serve this weekend, just before Polokwane. So on that basis, McCarthy must have known the indictment was ready to be served. But I haven't finished my submission as to why this was an abuse of such a nature that it was not in the interest of the public interest to continue.
No, but what's been put to you is whether in fact it was an abuse, and whether it had an effect. If you have regard to the fact, let's just recount the facts. Minister Mabandla herself was concerned about the timing, was she not?
But for a completely different reason to that of McCarthy.
No, but be that as it may, even if you bring in Mr. Casseroles at one stage, and what you make of him is a different question. But he too had similar concerns about what the effect might be. What the effect of serving before Polokwane in the light of heated political emotions.
But they were concerned that the effect might be that there would be problems within the country, as opposed to McCarthy's concern, which was that President Mbeki would not be re-elected. So he was prepared to delay the indictment for a valid reason. But it turns out that he was persuaded, whereas for the wrong reason. McCarthy had his own agenda. And when he found that out with the tape recordings, and then he took into account McCarthy's history with Browse Mole, he realized what he was doing and what he was up to.
Okay. Could I just understand that as far as you're concerned, whatever the objective factors might be, whatever Minister Mabandla's concerns might have been, whatever anybody else might have thought who had legitimate cause to think that timing was a problem because who knows what might happen in respect of instability, because that I think was the legitimate concern, was that not? National instability.
Well, that was Minister Mabandla's concern.
That was
and that was why Peshe was prepared to postpone.
But if you add what my sister Chiki put to you, to the question of they'd already had Justice Msimang being angry at proceeding without all the formalities being in place in the past. So in terms of whether the racketeering charges and the certificate was obtained properly, it was probably imperative to ensure that it was all in place before the indictment got served. Are we?
Yes.
Yeah. Well, if that is so, then how is the prosecutorial process? And that's the difficulty I have, that it's the prosecution itself. When you serve the indictment or how you serve it, how does that impinge on a case? And maybe in respect of Latif and all of those cases, and if you look at pages 130 to 131 of Mr. Misuse, he doesn't seem to do that weighing up process. He doesn't say to himself, well, hang on, how much of this, if we're talking rationality, how much of this, having discounted the three other factors, which is fair trial rights, having discounted the question of how you mount the defense, he says none of those impinge. He says, but it offends against one's sense of justice. Following the Latif and the other cases in the UK, the public interest ought to have been weighed up as well. Is that not correct?
Well, but that is what he said he did. He said, I accept the merits were good. I accept he would still get a fair trial. But in terms of Maxwell, there are two categories where you can stay a prosecution. The one is where you don't get a fair trial, and the other is where you have an abuse of this type, and you can stay the prosecution because the court won't countenance any kind of abuse that reflects not only on the integrity of the criminal justice system, but also on the integrity of the court.
Could we go to page 117 of Maxwell, where there's a reference to Latif?
Is this
it's in the bundle of documents. It's in the bundle of cases and articles.
we deal with it in our heads, just as that's paragraph 69 of Maxwell. Just find Maxwell.
Well, let's read it because it's important in this weighing up process, and the concerns raised by my brothers Leach and Kachalia, as well as by my sister Chiki, all come into it. The law is settled, says what Lord Steyn said in Latif. Weighing countervailing considerations of policy and justice, it is for the judge, in the exercise of his discretion, to decide whether there has been an abuse of process, which amounts to an affront to the public conscience and requires the criminal proceedings to be stayed. But what's important is the latter part of that quote. But it is possible to say, that's really at the end of that quote, that in a case such as the present, the judge must weigh in the balance the public interest in ensuring that those that are charged with grave crimes should be tried, and the competing public interest in not conveying the impression that the court will adopt the approach that the end justifies the means. So we must agree that that's what goes into the pot.
Yes, and in Mshe's statement, he plagiarized this, what he said from here.
Yes, accepting that I'm not sure he followed it to the letter, because he doesn't, where does he deal with the graveness of the offence in relation to the other public interest? Does he do that in the statement, Mr.?
Well, he does. He hasn't summarized his entire analysis, but he said, I took it into account.
But let me tell you about this plagiarism to which you refer, because that too goes to his state of mind. Here you have a director of prosecutions who plagiarizes some other judgment. All right? That judgment refers to an abuse of process. Abuse of process, as we know in our law and as we know in foreign jurisdictions, an abuse of process refers to an abuse of the court process. On appeal, that very judgment that he plagiarized makes that clear. It sets the judgment aside which he relies on. That is not disclosed to the court. So what he does is he invokes an abuse of process doctrine quite inappropriately. I'm prepared to accept that there may be cases of an egregious abuse of power by a prosecutor which may well warrant a prosecutor deciding that because of this abuse of power, I am going to stop the prosecution. I can accept that. But what he does is he invokes the wrong doctrine. The doctrine abuse of process deals with permanent stays. What I'm putting to you, therefore, is this. That is another indication of a man operating with at least no idea of what he's doing, or alternatively, not applying his mind at all to what he's doing. But with great respect, those reasons are nonsense.
Justice Kachalia, he referred to Maxwell. Maxwell said there are two categories. Where it will be, it is well established, says Maxwell, that the court has the power to stay proceedings in two categories.
You're going back. If you don't want to answer the question, you don't have to answer it. But I need some clarity on this. What I'm saying is those judgments refer to an abuse of process doctrine, abuse of a court process. It's a different situation. He cannot invoke a process unless he says, I'm invoking this as a comparison between what I'm about to do and the way the courts have approached in foreign jurisdictions the abuse of process in permanent stays. Then I can understand what he's doing, but that's not what he's doing. So that's what I'm putting to you, that he's barking up absolutely the wrong tree.
And I certainly will answer it, Justice Kachalia. Yes. I won't avoid the question. I referred to Maxwell, and I want to first quote from what Maxwell says. It is well established that the court has the power to stay proceedings in two categories of case, namely, one where it is impossible to give the accused a fair trial. I said that's not the case here. Two, where it offends the court's sense of justice and propriety to be asked to try the accused in the particular circumstances of the case. In the first category of case, if the court concludes that an accused cannot receive a fair trial, it will stay the proceedings without more. No question of the balancing of competing interests arises. In the second category of case...
Can we stop there? We're not in that category.
We're not in that category.
Okay.
In the second Cadre case, the court is concerned to protect the integrity of the criminal justice system. So if I can just have a moment to again say what happened. Downer was very concerned about not serving the indictment. The matter had already been struck off the roll by Msimangche. He was concerned about a permanent stay application. He didn't want this to happen again. And he in fact wasn't being told the truth, Downer, about what was happening. He was intent that the indictment should be served. And you've got the head prosecutor who is holding back with the indictment because Polokwane's come up and he's not running the prosecutorial process as he should with anybody else. He's keeping it in abeyance for one reason only, and that is to satisfy his own personal interest that his champion, President Mbeki, should remain the president of the ANC and become the president of remain the president of the country. Now that is the conduct. Can I add to that, Justice Kacharia? If one accepts that is the conduct, which with respect must be the case, if that conduct is serious, if it's egregious, as the DA themselves thought, as the court felt, then what it comes down to, it comes to rationality. And Justice Kacharia, in a recent decision which you gave in the Free State University matter and every forum, you said, when you look at the facts, once there is conduct, it falls within the discretion of the decision maker to decide how serious that conduct is. It's his, and how much weight to be given to that conduct. And it's not for me and it's not for the court. The court might well have done something different. The court might well think it's unreasonable. But the cases are replete with statements to the effect, whether it's Batterstar, pharmaceuticals. The fact is this court cannot look at it as what this court would have done. Lots of people here might have taken a different view, but it's not for us to second guess that. If this power is given to him in terms of the Constitution, he exercised that discretion. One doesn't like it. Can I just may. I want to try and make the point and I think I can make with this last reference. Corner House. The Corner House case which we refer to, there you had a situation where the investigating director in England was investigating possible corruption between the Saudi Arabians and an arms supplier. And what happened there is the Saudi Arabians, it was extortion. They said, if you carry on this investigation, if you carry on looking at accounts in Switzerland, we won't buy Typhoons from you, we won't cooperate with security, and we won't buy further arms from you. And he succumbs to that extortion. And the House of Lords says, as long as he's in good faith, it's his discretion. And lots of people were very, very unhappy about that, understandably so.
Are you suggesting that we would follow the same route if a similar set of, that our constitutional court would follow the same route?
No, I'm not. What I'm saying, what the constitutional court will say is, as unfortunate as it is, we cannot impede upon the discretion given to a decision maker in these circumstances.
Could we just wrap up the principles in relation to Maxwell, and it's in relation to what you read. You read from paragraph 13. You read about the two categories. And really, as my brother pointed out, this was in relation to an application for a permanent stay of proceedings, or at least in relation to a permanent stay of proceedings. Can we accept that that's the context in which it was?
Yes.
A number of those cases deal with police conduct, prosecutorial conduct in relation to witnesses and the like. It's manipulating the evidence and the process in relation to the prosecution, because it's under the heading prosecutorial misconduct. So far, so good.
Yes.
In relation to the second category, which is where we're not talking about fair trial rights, but we're talking about, and this is what it says at the end of 113, no question of the balancing of competing interests arises, but in the second category it does. The court is concerned to protect the integrity of the criminal justice system. That's what the second category is about. And then there's that last part in Latif, which is, but it is possible to say, and that's where the weighing up gets done. And the weighing up that gets done is not only that the public interest ensuring that those are charged with grave crimes. That's the second part that has to be weighed. That's not done by Mr. Mshe in his statement, Mr. I think you have to concede.
I do concede it. In fact, he concedes it because he says the merits don't come into play, or the merits are good. the prosecutors think the merits are good. So he must have taken it into account. He must have weighed it up. He says the merits are good.
He doesn't say I've done that weighing, and in doing the weighing, I come down on side X rather than side Y. Where does he say that? Because that's what Maxim says you've got to do.
Where's the statement? Where's the statement? I might highlight it. So if I can just have a moment to find the share statement, which I've got here, that I've highlighted.
It's at page 130, 131 of volume 1. So if you take the main bundle, you get it at page 130, 131.
So, as you read out earlier, Justice Nafsa, he said, the representation submitted by the legal representative pertain to the following issues, and the first one is the merits. And then he says, I need not say up front, we could not find anything with regard to the first three grounds. So we accept, he knows the merits are good. In fact, he ends off by saying that, by recording that the prosecutors, he says, let me also state for the record that the prosecution team itself had recommended that the prosecution should continue, even if the allegations are true.
Well, can I tell you what is fatal to the argument you're making now? Let's look at page 130. Let's go through it very carefully, because we've got to debate it conceptually in relation to the Maxim test, which I think you have to accept is the test. You propound it as the test. McCarthy, it's line 34 of page 130. Are you there? Look at page 130. It's
Is it
line,
after background, Justice? 102. Which is from yours?
could you just read it very carefully, where it says Mr. McCarthy used the legal process.
Yes.
It says Mr. McCarthy used the legal process for a purpose other than which the purpose was designed to serve. That is, for collateral and illicit purposes. Let's just accept that for the purposes of the argument. It does not matter. So he says it does not matter that the team acted properly, honestly, fairly, and justly throughout. Mr. McCarthy's conduct amounts to a serious abuse of process and offends one's sense of justice. Well, as Maxim tells us, it does matter. It does matter because it's the gravity of the offense and the process itself. What Mr. McCarthy did was not simply being over-diligent, it was pure abuse of process. Well, we know abuse of process has to be weighed up. That's what Maxim tells us. Go to the next page. If Mr. McCarthy's conduct offends one's sense of justice, it would be unfair as well as unjust to continue with the prosecution. He doesn't say, I've weighed the public interest in relation to the gravamen of the charges and in relation to the fact that it has to be weighed up. He says, I'm just putting one thing on the scale, and that's my conclusion.
Yes.
Well, am I wrong in that, Mr.
Well, Justice Nafsa, I think, with respect, that when he says, I concede the merits are good, the prosecutors want to carry on, he has taken into account there are strong merits in this case. And when he looks at the abuse of process, and he says, but the abuse is so egregious, and I'm going to make a finding to stay, it must mean that he says, notwithstanding good merits.
No, this is what Maxim tells us. This is what Lord Steyn tells us to do. Must weigh in the balance, the public interest in ensuring that those that are charged with grave crimes should be tried. That's the one part. The other one is competing public interest in not conveying the impression that the court will adopt the approach that the end justifies the means. All he does is he takes the second into account. Where does he ever say, I've had regard to the public interest that those charged with grave crimes should be tried? Where does he say that? Where at all in that statement? That might bring us to another point. We've got here Mr. Mshe is the central figure in all of this, isn't he?
Yes.
I mean, he's the central figure. Why is there no statement by him? Why is there no affidavit by Mr. Mshe other than a confirmatory? Shouldn't we be expecting that the central figure in this entire drama should be telling us what motivated him, what he considered, and that whole question about what he said to Downer, whether he, according to Mr. Hofmeyer, he told Mr. Downer one thing, but it wasn't the truth. It was an untruth. Why don't we have Mr. Mshe on affidavit telling us what he did, what he considered, how he dealt with Mr. Dana and how he dealt with all of these others.
Just Nafsa, there's a supplement. There is a supplementary confirmatory by him.
Yes, that's.
I think there's two affidavits.
Well,
there's that one, and then
take
there's
us to it. Take us to it.
got it in core bundle at volume 4, page 619. May I say while I'm looking for it, Justice Nafsa, that whilst there are conflicts in the affidavits, I had no hand in drafting them. Just want to mention that for the record.
Sorry?
I just want to mention that for the record.
We won't direct that.